Good morning. A fantastic judgment. One who wants to know the theoretical value of Quran, Sunnis, and the procedure for divorce. And this has been doctrinally delivered a judgment by Division Bench of Kerala High Court, RP number 936 of 2021. Reference has been sent to High Court. Number 1, 226 Article 25, 26 of the Constitution of India. It was held that in the absence of any other method to effectuate the right conferred on Muslim wife to terminate marriage at her own will when the husband refused to give consent, being prevalent in the country, the authority of the court in conferring the Muslim woman the right to invoke Khulla at her own will have to be respected. Quran lays emphasis on the power of authority and direct faithful to follow the authority. The judgment discuss about various words and particularly they say the rights and obligations conferred upon believers in Islam cannot be denied for want of a system as envisaged in Sharia. Sharia means Shariat. Istishan, ISTIHSA, an Arabic term for juristic discretion that has been defined. Then they say, thereafter they have discussed defining law, declaratory law, or the classification of nature of law given in Quran. Then they say, Sana is secondary source of legislation. Then the primary source of legislation is Quran. Dissolution of Muslim Marriage Act 1939 has been discussed. Contemplating dissolution on fault grounds cannot be equated with Khulla, which has always been recognized as a mode of divorce on a no fault basis. Then I will read the relevant portion. If you go through relevant portions, they have discussed about one advocate Hussein, who is a Muslim scholar. He assisted the court to deliver the judgment. They say in the Holy Quran, chapter 2, version 229, the right of Muslim has been explicitly referred to, which reads as follows. They have discussed about that version. You have to go through that. Then they also discussed at para 10 that Sharia is based on 4 sources: Quran, Sunnah, Qiyas, and Ijma. So they say that also you have to go through it deeply to understand. Then according to Quran grants woman right to obtain Khulla. They say it in Juberia Abdul Majid Pantni vs Atif Iqbal Mansoori and another case, AAR 2014 SC 224 online. The court had adverted to the form of Khulla followed to decide upon a question arising under the Protection of Women from Domestic Violence Act. Then they say they have also discussed about Abdul Rahman, his book Principle of Islamic Jurisprudence. So that you have to read it if you want to understand what the Muslim law deals with. Then they say in chapter 4 verses 35 the Quran particularly refers to marital disputes and commands the believers to follow proper conciliation to resolve disputes. Then according to Al-Qurafi, the prophet functioned in 4 distinct capacities. He acted as messenger, mufti, judge and imam or head of the state. His action thus constituted either verbatim communication from God, fatwas, judicial rulings, akam, sing, hukum, or discretionary injunctions, tasarufat, sing, tasaruf, enjoyed by the head of the state. Then M.H. Kamli, principle of Islamic jurisprudence. Then the life history of Muhammad Nabi was directed to be followed as sanas. For that they have discussed at paragraph 19 that they say Habiba, how Habiba was adamant in joining with her husband and what had done with, and then Rubia, daughter of Muawiz, then Caliph Osman's dealing with that situations were discussed. Then they have discussed at para 21 as to how Quranic verses should be discussed along with the Sunnah. Then the Qadi cannot be equated with a court in modern of Qazi, modern state. So they say that was all these things. Then the residuary grounds referred under section 2(9) of Dissolution of Marriage Act cannot be equated with Khulla. Dissolution of Muslim marriage only contemplates dissolution of marriage at the instance of Muslim women on fault ground. Khulla is a different no fault ground. That is most important. Therefore, filing dissolution of marriage under Muslim marriage, dissolution of Muslim marriage act is something different from getting approval of Khulla from the court by filing suit. That is most important. Then the Sanna, they say Sanna is a second source of legislation. Then finally, they say Anibali definitions of Istishan. Istishan has been defined at various paragraphs, particularly Doctrine of Juristic Preference in Islamic Law by Saim Kayadibi. He also discussed about what is Istihsan. Finally, they say Istihsan is a doctrine for the courts to adopt and apply if there are no other methods to streamline the rights conferred on believers to act upon. So, assuming that the argument of the review petition holds good in the absence of any mechanism in the country to reorganize the termination of marriage at the instance of wife when the husband refuses to give, the court can simply hold that Khulla can be invoked without conjunction of the husband. Therefore, they dismiss the review application. So, it's a fantastic judgment. Kindly go, if those who are interested in higher studies about personal law, particularly Muslim law, and if you want to write thesis or dissertation about what is Khulla, what is facilitated provisions on fault ground. Fault ground means there is maybe some lapses on the part of the respondent. No fault ground, simply you file divorce. Just like irretrievable marriages, reunion is not possible because of the living nature, residing abroad, and so many things are there. That is maybe no fault, irretrievable marriage ground. So you should understand this judgment. The judgment was written by Justice A. Muhammad Mustaki, sitting along with Dias, DIAS, CSDS, CJJ. So it's a division bench judgment, AR 2023, Kerala 33. AR 2023, Kerala 33. Kindly go through the entire paragraph, running from page 33 to 48. Apart from that, if you are interested in challenging the Uniform Civil Code, you can also refer this judgment by analytical study of the judgment, various paragraphs about what was Sunnah, what was Quran, what was the dictum of the God. This is nothing but ordaining the society with orders. If a man wants to be a part of the society, the primary condition was he should get legally or regulated marriage and begotten the children in an approved way. That should be the concept of every society, which was subsequently regulated by the religious governors or whoever may be prophets, etc. Best wishes.